More on today's historic arraignment, we are joined once again by Loyola Law School professor Jessica Levinson. Professor, thank you so much. Want to get your reaction to his reaction. So after the historic federal arraignment today, he stops by a surprise visit to a well-known Cuban restaurant. He reportedly buys everybody a meal there. Now he's amongst his most loyal supporters, saying he's going to fight this. We will win bigger and better than ever before. What do you make of his reaction?
Well, I think it is predictable, and I think politically it's smart to, right from the federal courthouse, erase the image of him in a Suburban going into that federal courthouse and the image everybody can conjure up of what's happening inside that courtroom, and erase that with what looks like a typical campaign stop that we're used to seeing. This is a popular restaurant. Candidates generally stop there, and he's trying to essentially say business as usual. And now I think in his speech tonight to his supporters, it's going to sound like what he typically said, that this is a political witch hunt. This is the weaponization of the Department of Justice. And that is also business as usual for the president.
Yeah, he stopped by Versailles, which has great plantains, by the way. So let's talk about what he was just laying out, which we heard a few minutes ago, which is basically a preview, I guess, of what his defense is, which is over the Espionage Act, which is what he's being charged under. Without getting too in the weeds on this, can you sort of break down what he's being charged with and what he's saying about this that doesn't quite seem to be accurate?
Right. So one thing I will say is throughout this process, let's all be very careful to listen to the difference between what the former president and his representatives say outside of the courtroom, where there really aren't repercussions for misleading people and for outright lies, versus inside the courtroom, where there are repercussions for misleading a federal judge and or filing things under penalty of perjury. So briefly, what he's charged with is a violation of obstruction of justice, conspiracy to commit obstruction of justice, and a portion of the Espionage Act, all of which relate to him keeping government documents that he was not entitled to have and then not giving them over when he was asked to give them over. Let's remember, he did give over about 137 documents when he was asked, either by the National Archives or later by the Department of Justice. There are no criminal charges that are related to the documents that he did give over. This is all about the ones that he kept, and that he ultimately, some of which were only discovered after the FBI executed a search warrant.
Well, we know that he's having trouble, reportedly anyway, wrangling together a defense team. If you were his defense team, what is his defense?
So I think that what we're going to hear is essentially a three-pronged approach, but focused on the idea that the evidence that came from his former attorney, Evan Corcoran, that should not have been part of the indictment, because we only got that because another federal judge says the attorney-client privilege, which typically exists, there was an exception to that privilege for the crime fraud. It's called the crime fraud exception. And I think what we'll see is that the former president and his defense team will very aggressively say the attorney-client privilege should apply, that judge was wrong to say the crime fraud exception applied, and therefore a jury should never hear all of that, frankly, quite damning evidence. I think we'll also hear some arguments about selective prosecution and some arguments potentially about declassification. I don't think those particular defenses are likely to go anywhere.
Jessica Levinson, thank you so much for your perspective. She's a professor at Loyola Law School. We want to take